Welcome to another episode of Badges to Briefcases, the Gans Law podcast. I'm your host, Attorney Brandon Gans. With me, I've got my co-counsel, Attorney Danielle Padilla.
Hi.
Morning, Danielle.
Good morning.
All right, so today's topic is pretty exciting. We're going to explain the difference between burglary and robbery.
Yeah.
Because there's a lot of confusion, right?
A lot of confusion.
People mix this up sometimes.
Absolutely.
Yeah, it's kind of like assault and battery. Two different crimes.
Two different crimes.
Yeah.
But people often think they merge, and they really don't.
Right. So I think it'd be important if we kind of just went over like, well, what is a burglary? What is a robbery?
Absolutely.
And go from there. I almost forgot, if you don't already follow us, Gans_Law on all our socials. Got to get that plug in.
Yes.
Okay, so a burglary in Florida essentially is entering of a dwelling, a structure, or a conveyance with the intent to commit a crime within, right? So what does that mean? Well, what would be a dwelling in Florida?
Your house, your
A
home.
residence,
Yeah,
right?
a residence. Yeah.
Yep, and then a structure.
A structure could be a trailer.
Yeah, any building that you don't live in very much.
There you go.
And then finally a conveyance.
A car.
A car could be a
Yeah.
conveyance, exactly. So if you enter any of those things with the intent to commit a crime, that's a burglary.
That's it.
Okay. Robbery, I actually wanted to read the definition of robbery
Yes.
because it's a little bit more
Interesting.
convoluted. I'm going to read it, and then I will give a human explanation of what this means.
Right.
The definition in Florida of robbery. Robbery means the taking of property. I'm sorry, let me start again. Robbery means the taking of money or other property which may be the subject of larceny from the person or custody of another with intent to either permanently or temporarily deprive the person or the owner of the money or the property when in the course of the taking there is the use of force, violence, assault, or putting in fear. Pretty simple, right?
So many layers, though. That's
Basically-
like an onion.
Yeah. It is an onion. So let's peel back the layers. So
Yeah.
essentially what it means in human terms, you're taking someone's property from them with force or threatening force. And that's really
Beautiful.
it. Doesn't have to be money, but it does have to be taken from them. Now, I think that's a big distinction between robbery and burglary.
Absolutely.
So I always think of robbery as like a person crime and burglary more like a property crime.
I love that.
Yeah.
I love that you put it like that because oftentimes people are not realizing that that is the key difference is you're having a person when it comes to a robbery who is to some extent aware of what's going on. That is a huge element. And
Yes.
if you're missing that element, you have to meet all elements. You're not going to have the robbery.
Right.
But with a burglary, that doesn't have to come into play
Exactly.
to qualify as a burglary. So I like how you put that.
Yeah, and one of the
very good.
misconceptions I think on that point is when, someone will report, oh my God, I've been robbed.
Yeah.
Well, when they get home, they find their house has been
Yes.
tossed, things are taken from their home, but they weren't there, they didn't witness it, and they say, I've been robbed. Well, you haven't been robbed, but you have been burglarized.
Right.
So it's not great.
They do use
But it's
that
not a
word
robbery.
loosely. Yep.
Yeah, so
Absolutely.
I think that's one of the huge misconceptions to say, I've been robbed, when really the crime would be burglary, right,
Absolutely.
in that situation.
Absolutely.
If you've been robbed, you know right away.
Absolutely. Because
Someone's taking
it goes
from
back,
you.
exactly. It goes back to that element that to a certain extent that person is aware is being placed under fear or there's force or anything that's going to qualify. So they are very much involved for it to qualify as a robbery. With burglary.
Right.
They don't have to be. You don't
Right.
even have to be in your house at the time that the burglary is being committed
Yeah.
for it to qualify as a burglary.
And most of the time you're not, right?
Exactly.
Most of the time it's unoccupied dwelling.
I mean, that's what people try. That's how people try to get over you, right?
Sure.
They try to go in when they think that a home is vacant, right? To go in and out nice and clean and commit the crime therein that they are
Right.
there to do. Doesn't mean that sometimes they're not met with a surprise when someone's inside, but that's a different
Yeah.
conversation for another day.
Exactly. And
Yeah.
so it's typically more of a stealthy type offense.
Absolutely.
So burglary, you're entering with the intent to commit a crime, but it doesn't necessarily have to be a theft, which is, I think, another surprising thing. People think burglary is you're going in to steal something. Could be any
Anything.
offense. Anything.
Anything.
So
I think that oftentimes where people would, when I was in law enforcement before, where people would be shocked when they were charged, right, with a crime. When it came to burglary, the one that would shock them the most would be burglary within a conveyance with a battery therein. So
yes.
you're going into someone's vehicle. It could be as simple as you're arguing with someone. They're in a parked car. You're standing outside the car. You guys are arguing. They have their window down. And now you throw yourselves into their car to, let's say, choke them, choke them, punched them, whatever. You're in their car. You have entered their property. You are in their car without their consent with the intent to commit a crime therein. You are committing battery. They would say, I didn't do no burglary. I didn't take anything. I would tell them that's not what this is.
Exactly.
It's not.
It's confusing to a lot of people, and even maybe lawyers that don't even practice criminal law, how that could be a burglary.
Absolutely.
You reach into someone's car and just to touch them or whatever. Well, now that's a misdemeanor battery.
Absolutely.
Plus, you've crossed the threshold of their open window, entering their conveyance.
Absolutely.
So now it's entering with the intent to commit a crime.
Yeah.
And that's a burglary.
It sucks when you catch that charge.
It does. That escalates it pretty quick.
And
from a
people
misdemeanor
don't
to a
think,
felony.
because you're in the heat of the moment. Most of the times when you're in a situation like that, you're in the heat of the moment. You're not thinking you're rising to the level of committing that type of crime. I think you think in the moment, I'm just beating someone up. I'm committing a battery.
Yeah.
So when you hit them with the other part of it, they're like, no, that doesn't even make sense. But to the law, it does.
It does. And unfortunately, if it's a burglary and the crime you're committing is battery, that elevates it sometimes to a PBL, or what we call punishable by life, which is wild, because I've had cases too where someone just reaches through a car window, they get into a little slapping fight or whatever with another driver or whatever. Well, now you're looking up to life in prison for that.
Yeah.
It's just wild. Where if it had occurred outside the car, you'd be looking at only up to 1 year as a misdemeanor.
Absolutely. I want to say, a case when I was in law enforcement where it was a bottle that the person threw into the car. It hit the person's eye, blackened their eye pretty bad. They got charged with burglary with a battery therein. And it's like, how? You threw something into the car. Like, but most people don't see it coming.
No, I mean, it's
tough.
It is. It's one of those legal technicalities that it is the law, but it's not something I think most people are aware of or would expect or
Not
even could think of in the heat of the moment.
Yeah, absolutely not.
That's that's where we come in as defense attorneys now.
Right.
Okay, the same thing with robbery. People think robbery always has to involve a weapon. Is that true?
No, not at all. Yeah. It's as simple as just placing someone in fear with your words. Give me your purse or I'm going to kill you. And what if the person just has their hand behind their back? Now this person's in fear, believing, oh my God, behind their back, they have a gun. They're going to kill me. They're going to shoot. Here's my purse. Yeah. That's all it takes.
Yeah,
and maybe
we're not
he has
even
nothing.
that. We're not even that. If it's just, the person doesn't have a weapon, but they're still threatening harm. Maybe it's a bigger person or whatever. That's all it takes for robbery.
That's it. As long as the person was placed, in fear with the words, I mean, no matter what was said, they're scared in that moment. And you're trying to take their property. Yeah. I mean, it's going to meet it.
And there's really no, minimum value for the property. So it doesn't really matter how small or invaluable the property is.
That's a good point.
That doesn't make any difference.
It could be very minute.
Yeah. So, and the same with burglary. I think a lot of people might think, well, for a burglary, you have to take something. But like we just talked about, not necessarily true.
But the intent. It's just you just have to have the intent to commit a crime therein.
So you don't really have to commit the crime.
You don't have to complete it at all. You can go in there. Because, there are cases like that where the person, breaks into the property and has the intent to commit the crime. And let's say, kind of like what we just spoke about, they thought the property was vacant. And actually it's not. There's someone in there. They hear a noise. They get startled. They leave. They don't finish what they intended to initially do. I mean, but that's not going to change the circumstances. You still, broke into a place, went inside with the intent to commit a crime. Whether it was finished or not is irrelevant to meet the statute, know? Now, I mean, can you, later down in litigation, use it as a mitigating point? Like, and kind of, go based off of that to see if we can kind of soften the blow a little bit.
Sure.
But to meet statute, you don't have to complete the intention of the crime that you wanted to commit.
That's true. And so that's an advantage that the prosecutors have. As defense counsel, there's cases I've handled, burglary cases, where I've done plenty of them, where, yes, we can say, yes, they entered the property, right, without permission. Yes, they committed a crime within. However, at the time they entered, they did not enter with the intent to commit that crime. Maybe they were doing something else. Otherwise, it's essentially a trespass.
That's what I was going to say. Yeah. So in cases like that you've litigated, I would assume that's probably your end goal, right? To get an amendment and get it down.
Yeah, if you get a burglary amended to a misdemeanor trespass, it's usually pretty
Absolutely.
good.
That's a win.
That's a win.
That's a win.
Or dismiss completely. Even
Yeah,
better, right?
absolutely.
Yeah.
So that's a really good point.
Yeah. So let me ask you, as your 5 years as a police officer,
Mm-hmm.
you probably investigated tons of burglaries, robberies.
A ton.
Yeah.
A ton.
On a burglary case, when you get on scene, what is it that you're looking for?
I'm looking at point of entry. I'm looking at, obviously, do I have witnesses? Because that's going to really narrow down a lot of things, right? What was taken, where they entered, where did they exit? How they entered is not always how they exit. Were they successful in committing the crime they're in? Or was there another crime? Like you said, it doesn't have to be taking property. Was there something else that happened inside? So witnesses are going to be crucial. I'm looking for cameras. I'm looking for disarray of property, because that will kind of like give me a point of investigation of they were in this room, they focused in this area, something happened here, whether it's trying to steal property or whether it was a battery that was happening inside of that room. It's going to give me an indication of narrowing down in the house, let's say, what happened. Then from there, we carry little kits and we start looking for fingerprints, right? When we narrow down certain sections, we start fingerprinting.
So this brings back memories for me. The kit. You go to the trunk, you get the kit, you bring the kit out. So for people that don't know, what's in the kit?
Yeah, the kit, you're going to have, obviously, your gloves, because that stuff is messy,
Yeah.
a little brush, the powder to lift the fingerprints, your tape, your cards, where you lay down the fingerprints. I think that's what all my kit had, right?
Yeah. It's the main parts of it. So.
And it's like a little toolbox that the PD gives you, and you carry it around in your trunk.
Yeah.
And
were you pretty good at lifting prints?
Yeah, I was pretty good. I would try to get a lot of prints, because you just never know. And the thing is, just like anyone's home, they're full of prints.
Right.
Right? So you can't just stop at the first one, second one you lift, because it could be the homeowner, or it could be a friend that comes over all the time, or a child. So you can't just be like, oh my God, I got one.
Right.
I'm golden.
Because as a defense attorney,
look.
if it is a neighbor, someone that routinely does have permission to go over, just because you pulled our client's prints off there doesn't mean was from the date of the unauthorized entry.
Absolutely. Yeah. So I would definitely collect as much as I could, take pictures, because pictures can be very telling of a story, right? So I would take a lot of pictures, gather any witness statements, and depending on the severity of things, then I think we make, as law enforcement, we would make a judgment call of, are we going to call out crime lab? Because sometimes the bigger and heftier the burglary is, or, when it's a robbery, sometimes, regular patrol, we're only limited in scope how much we can really gather evidence. But when it comes to a bigger scene and a bigger crime, sometimes it's best to call in crime lab, leave it to the professionals that do all that kind of stuff, and then they'll come and process the entire scene. They'll take their time. It could be their hours processing an entire scene, especially if it's a huge scene. Sure. So that would be a judgment call I would make, and then sometimes you also make a judgment call whether you're calling CID out and you're getting a whole detective to start making some additional judgment calls.
Depends on the situation.
It's a lot that goes on.
It could be, yeah.
Man, I just noticed.
Yeah. It sounds like a lot, man. It sounds like a lot of work.
Yeah, it's a lot.
But I think it definitely in my experience too, I think if you are processing it, the responding officer, you can kind of tell who cares and who doesn't.
Absolutely.
Some won't take prints.
That's
Other ones
crazy.
will try to take prints. Like, oh, there were no prints. Like,
That's
really, no prints on
crazy.
anything? No.
That's impossible.
Well,
yeah. Any home is going to have, you're constantly touching things in your house.
Right.
So at a minimum, you're going to find
or a
print.
car door handle. Really, nope. You couldn't get any prints. I don't think they were trying, but
Exactly.
that's my.
I would always collect
I know.
prints.
I'm sure you're very thorough. I've seen your work here. I know you're thorough. So what mistakes do you think that people make when talking to law enforcement during these cases, maybe if they're being investigated or if they're a suspect in a type of crime?
You said it. You said the word talking.
Yeah.
Why are you talking? We already talked about this on a podcast episode, don't talk.
Yeah.
Don't talk. Why are you talking? And I'll say it again. I don't care what you think your story is and how valid and understanding and clear and true and right it is. It's never going to be enough for law enforcement.
Right. And I understand people want to cooperate. You can still cooperate through the use of an attorney.
Absolutely.
There's nothing wrong with it.
Absolutely.
It's constitutional. You have that right.
Absolutely.
So it's not that, they say, oh, you don't want to talk to police, you must be guilty or you have a guilty conscience. Not necessarily true.
No.
You just want to have your counsel do it. Maybe they're better spoken than you. Maybe there's other reason to have an attorney.
And like I always say, at the end of the day, that's your Fifth Amendment right. Like that is your right. You don't have to talk. You don't have to. And I like how you phrase that. There's other ways where you can show cooperation. I mean, sometimes cooperation with police is as simple as just complying with the arrest, not fussing, not cursing at them, not being belligerent, not resisting, because that's a whole nother charge. Just comply, use your manners. It's not going to change. They're putting you in handcuffs.
Right. You don't have to give a statement.
Correct.
It's not obstruction.
Correct. Yeah. And listen, my belief, oftentimes you giving a statement or not giving a statement is not going to move the needle. You're still being put in handcuffs because 9 out of 10 times, by the time that they're talking to you, they've already developed probable cause to put you in those handcuffs. It's not going to move the needle. So sometimes I tell people, they're like, oh, but like if I wouldn't have talked, I felt like I was going to automatically be put in handcuffs. And I look at them and I'm like, at that point, you were already deemed to be in handcuffs no matter what. And that's what people most of the time don't realize. I believe in just don't talk, comply, show your manners and just don't be belligerent because that makes it worse in the long run because these officers will tell that to the prosecutor. He was belligerent, he was this, he was that, she was that. And it'll be in the report. 100%. And guess what? And then that's going to come up. Yeah. And prosecutors will bring it up, right? They'll bring it up to us like, no, look at what the report said, blah, blah, blah. And it does give us a little bit more pushback when we're trying to litigate. It makes it a little bit harder because it's not a good look.
No, I had a burglary case that I could have gotten dismissed or reduced, and the prosecutor was really hanging on to the fact that the person just wouldn't cooperate with law enforcement. That's different than not giving a statement, but different. Just being the attitude.
People don't see that.
I'm not saying that's a valid reason to, but it is a reason that prosecutors will use.
They will hang their hat and they will stand 10 toes down on the charge, and something that maybe mitigation could have been helpful for if they see that you weren't complying and you were rude. Especially if it's an officer that has a reputation of being professional and doing their job the right way, and they're liked by the prosecutor and have a good reputation within the community, the legal community, that's never going to be good.
No. And, I think sometimes prosecutors and maybe police officers can be overzealous sometimes when overcharging. Have you ever seen them overcharge like on an arrest? Or
absolutely. I remember, when I first started litigating cases, I went to initial appearance for a case in which it was actually a robbery, a shooting. I mean, it was like 10 different, I could go down the list, 10 different charges. And it was that overcharged. And so when I started digging through the facts, I'm like, they don't have probable cause to meet the elements for this, but that's where you have an attorney come into play to make those arguments at initial appearance. So I looked at the judge and I said, Judge, I got a PC argument. Go ahead. All right, for count 1, we don't have it. And this is why. Statute says, where in the facts does it say that? Nope, we only have this. We don't have all elements. Yep. And by the end of that initial appearance, the judge was like, you're absolutely right. And the charges were reduced. Yeah. I mean, it's not... This very early in the game. That's 24 hours into your arrest. So to at least see charges reduced, 24 hours in, that's a win.
Plus it reduces the bond.
Yeah, that's a win.
Yeah, that's a huge win.
So, absolutely. I mean, you have to look at that. But yes, these officers do sometimes just...
They're stacking the charges because they're making a recommendation. They haven't consulted with the state attorney's office yet most of the time. Yeah. Unless it's like a huge case, then they'll consult. They'll call like the on-call state attorney. But most of the time, they're making the decision. And, for most departments, I would imagine, I know the one I worked for, you had to run your charges through a supervisor first for the most part, to make sure. But sometimes even the supervisors will rubber stamp it or agree, or maybe even tell you, hey, you need to upgrade this. Now, sometimes they catch it and they downgrade it.
I've seen that happen where a supervisor definitely was like, absolutely not, get them out of the back of your car. This is not that. It's not going to meet it, and thank God the incident I saw was caught before the person was in jail, because then that's a whole different issue. So that was good, but it happens most of the time. Yes, the supervisor is going to want to see your report that you've typed up and approve it for PC before they send it off and give the blessing. Yes, you can head to the jail. It's good, but let's be real. Sometimes maybe you have a supervisor that's brand new.
Hey everyone, today's episode ran long, so we're going to divide this into 2 parts. I hope you enjoy.